defenders and prosecutors, so they know both of each other's perspectives and how to act out both roles. Okay, so some similarities and differences between prosecutorial misconduct here and in the UK. Institutional racism, it plays a huge factor. You are more likely to be a recipient of prosecutorial misconduct if you are a person of color, and also one of the most rampant forms of prosecutorial misconduct is the abuse and misuse of evidence. And so more uniquely to the United States is the concept of prosecutorial immunity. There are two different types, absolute immunity and qualified immunity. And absolute immunity provides prosecutors with, like it says, absolute immunity, and they don't have to have any repercussions for their actions as long as they're doing things that take place within the guidelines of what a normal prosecutor would do, such as deciding what cases to prosecute, what defendants to charge, what to argue in a courtroom, and even what evidence to disclose. And qualified immunity has a really, really flexible definition, and it's kind of up to the opinion of who's making the call if something qualifies under qualified immunity. And so qualified immunity is really speculative, and it gives immunity to prosecutors who are performing tasks that are outside of the regular prosecutorial duties, such as maybe conducting a press conference or going on site to going on a crime site with police. And this gives so much room for opinion, and they're only not qualified for qualified immunity if they don't think that a reasonable prosecutor would have acted in that way. Something more unique to the UK is prosecutor's fallacy, and prosecutor's fallacy is when prosecutors don't have enough evidence to prove someone is guilty, but they also don't have enough evidence to prove someone is innocent, but they kind of just go with the guilty side because it seems slightly more probable that they might be guilty than innocent. And just to exemplify, there are two cases that I would like to highlight. The Stephen Linscott case, which took place in Oak Park, Illinois, a suburb of Chicago. He was convicted in 1982 of a rape and a murder, and he told the cops about a dream that he had that kind of represented the case, and they took it as a confession. And then later in court, prosecutors deliberately lied about DNA that was found on the scene, and he was convicted from lies from prosecutors and also hair DNA, which is not a reliable source of DNA. And in the United Kingdom, Sally Clark was sentenced to 2 life terms because she was charged with the murder of her 2 infants, which each died a year apart. And this conviction was based on a false statistic that was given not by a statistician in the court, and the prosecutors allowed it. They said that there was a 1 in 73 million chance that a woman of her stature was able to have 2 children that died of sudden infant death syndrome. So she was later exonerated for that. And some possible solutions that I thought was maybe to merge the adversarial system and the inquisitorial system. I know that the UK kind of is a combination of both, but I think it would be beneficial in the US for us to examine that. And definitely in the US to equal the playing field between public defenders and prosecutors. Also to reevaluate judge election reform and how that rolls out in the United States. And to definitely reform prosecutorial immunity. I know it was recently looked at, but it needs to be open again. Thank you.
You can go ahead and close that out. Okay. Nobody close that all of them, right? You can go list them.
Alright, so I will be focusing on prosecutorial misconduct too. My name is Loundy. Here I give some information about both countries, their population, their government, and their legal system, and also the population, the prison population, which in the United States has the highest prison population in the world. The prison population of the UK as of November 23rd, it was 36,158. So the United States, like my peer mentioned before, they have absolute immunity from civil liability. They cannot be sued for their involvement in wrongful convictions of or miscarriages of justice. There's also the harmless error rule, in which appellate courts they are authorized to ignore errors in trials by the prosecutors unless they violated the defendant's rights. Prosecutors in the United States have a lot of power. They are often left to regulate themselves. They have the power to decide on what charges to prosecute. They can interview eyewitnesses. The criminal, I put criminal behavior and I put a question mark because many prosecutors involved in the fabrication of evidence, and they also let eyewitnesses commit perjury, which is a felony in all 50 states of the United States. They often involved in dishonesty. They fail to provide the defense attorneys with evidence that can help the defendant. There's also prosecutorial vindictiveness, in which they threaten defendants to charge with higher cases unless they cooperate with them. Usually this involves juvenile individuals. They can threaten them to charge them as adults if they don't cooperate with the prosecution. Accountability, they are rarely accountable for their acts. Prosecutors they never face disbarment for their wrongful behavior. And in some cases, they face minor fines and suspensions. The United Kingdom has the Crown Prosecution Service that was created in 1985. They have a limited amount of power. The police has most of the power. The Crown Prosecution Service only functions as a review. It reviews cases referred by the police. They can only prosecute if there's enough evidence and if it's in the best interest of the public to press charges. They prepare cases and they present them either to the magistrate's court for minor cases and to the Crown Court for serious cases. They also have they treat their eyewitnesses better than in the United States. They have a witness care unit which takes care of arranging child care for the eyewitnesses, children. They can make screens that may shield witnesses from the defendants. Arrangements can be made to get evidence via a live TV link. Judges and lawyers can remove wigs and gowns to make the eyewitnesses feel more comfortable. And they are definitely more accessible to the public. They have a website in which they provide all the information and all the services. And they also post videos on YouTube to reach a greater audience. There was also the Gladwell Committee that was concerned with improving the efficiency and the effectiveness of the case preparations. They made proposals and they are now being implemented by the CPS. And the remedies. In the United States, we should be able to press charges on prosecutors that engage in criminal behavior. Prosecutors who do not abide by the code of conduct should be fined or disbarred, depending on the infraction committed. Prosecutors and judges should be evaluated on wrongful conviction and miscarriages of justice committed on their part. Judges should be assigned and not elected. The U.S. should implement a system similar to that in the United Kingdom, Kingdom, in which individuals get warnings or minor infractions, and so they get a second chance and they're not charged with crimes, and especially in the cases involving juveniles. In the United Kingdom, the government needs to provide more funding for the CPS to raise the salaries of the staff. And they need to work more in conjunction with the police and have more power to investigate on the cases.
I know it's so hard when you're like on the road and it's just what you want to just go on about. That's always when we run out of time.
All right, my name is Clay Stampa, and I will be presenting on wrongful convictions and inadequate defense. So the questions that this presentation will be addressing, what are the causes of defense errors? How do these causes differ in the US and the UK? And what remedies can be pursued to minimize defense errors? So there are a couple different types, or a couple different ways that defense can be inadequate. In many cases, especially with the Public Defender's Office, they're simply overworked. The lawyer has taken on too many cases to devote enough attention to any of them. In some cases, they're underqualified. Some of the cases that we looked at, there would be like a family lawyer representing a defendant on trial for murder. So obviously they don't have the same experiences